All right, this is the reply to the state's response to Aaron Spencer's motion in limine to exclude evidence. Spencer is charged with second-degree murder of Michael Fossler, specifically that Spencer knowingly caused the death of Fossler under circumstances manifesting extreme indifference to the value of human life. Spencer has asserted the defense of justification pursuant to Arkansas Code 52607. A person is justified in using deadly force upon another person if the person reasonably believes that the other person is 1. Committing or about to commit a felony involving physical force or violence, 2. Using or about to use unlawful deadly force, or 3. Imminently endangering the person's life or imminently about to victimize the person from the continuation of a pattern of domestic abuse. Spencer has also asserted a defense pursuant to Arkansas Code 52604. A. Conduct that would otherwise constitute an offense is justifiable when 1. The conduct is necessary as an emergency measure to avoid an imminent public or private injury, and 2. According to the ordinary standards of reasonableness, the desirability and urgency of avoiding the imminent public or private injury outweighs the injury sought to be prevented by the law prescribing the conduct. Both statutes are justification defenses under Arkansas law. The state's charge requires proof beyond a reasonable doubt that Spencer knowingly caused Fossler's death by deliberately creating a risk that was practically certain to result in Fossler's death. The state must further prove that Spencer did not act under the reasonable belief that Fossler was committing or about to commit a felony involving force or violence against Spencer or Spencer's child, or that Fossler was using or about to use unlawful deadly physical force against Spencer or his child, and that Spencer's conduct was not necessary as an emergency measure to avoid an imminent public or private injury, and the desirability and urgency of avoiding it outweigh the injury sought to be prevented by the murder statute. Both defenses are to be submitted to the jury if there is any evidence admitting supporting the defense. And if so, the court shall charge the jury that any reasonable doubt on the issue requires the defendant to be acquitted. Thus, the state must disprove these defenses beyond a reasonable doubt. The state's factual recitation is misleading and omits material facts. The chain of events that led to the death of Michael Fossler began in July of 2024, when he repeatedly sexually violated Spencer's daughter, not, as the state would have it, when Spencer first learned of the horrors Fossler had perpetrated against his child. The chain of events that resulted in Fossler's death definitely began with Fossler repeatedly sexually assaulting a then 13 and later 14-year-old child. The chain of events continued with Fossler being arrested and released for those crimes, yet continuing his manipulation and deception. He could continue assaulting the child until finally someone realized that he had taken her away from the home during the night. Footnote 1. Alright, so here's the first footnote. It seems that the state is sensitive about the language used to describe the 67, so he's not 64, he's 67. 67-year-old Fossler picking up his 14-year-old sexual abuse victim so that he could take her to another location to commit more sex crimes against her, but surely no one can argue that he did not take her away from the home in his vehicle that night. When Fossler realized that the Spencers realized that he had taken control of her that night, he fled with her, refusing to surrender her. The chain of events that led to Fossler's death began and ended with Fossler's criminal acts. The state's suggestion that the chain of events that resulted in Fossler's murder was Spencer looking for information about Fossler from the mutual acquaintance is yet another attempt to distract from the chain of events that Michael Fossler started and perpetrated until his death. It is yet another deeply concerning indication of its failure to blame the blameworthy, the dangerous pedophile, instead of the man who found his daughter under the control of the pedophile. And while the pedophile was facing multiple life sentences and then some for his abuses of her. The state also repeatedly manipulates the statements and evidence in its response. For instance, the state says that Spencer told Higginbotham, "Don't call anyone, don't call the police," although that is not precisely what Higginbotham told police shortly after. When he came to speak with Miss Higginbotham, the person whom Fossler accessed the child, Spencer actually said, "Don't call anybody." She felt because a family member had been through a child sexual assault incident and the local police department in this jurisdiction had re-victimized her instead of helping her. She explained that Spencer had just learned of the assault from his daughter, although she did not seem to believe it was true, and he wanted Fossler's contact information. The state also omits the context as to the history of the family connection between the Spencers and Higginbothams and her role in the events that led to Fossler's abuse of the child. The state's response then purports to describe the events when Spencer arrived at Spencer's residence in regards to the rape allegations. In addition to the family's knowledge of local law enforcement's failure to assist in a prior child sexual assault investigation, Spencer knew that Fossler had a history in law enforcement and the military. Although the state focuses solely on Spencer's visceral reaction to learning details of his daughter's repeated rape by Fossler, the reality is that within about 7 minutes, the Spencers agreed that the child would speak to a female officer, and the conversation moved to exchanging information and proceeding with an investigation. Spencer and his wife then spent the next hour and 8 minutes or more talking with the officers about the family history, the situation that led to the child's interactions with Fossler, and information the child had reported to her mother. While waiting on the other officers to respond and filling other time with cordial discussions about everything from the military to animals to movies, Spencer and his wife invited officers to park in the driveway, invited them to sit on the porch, and offered them water. They completed forms and signed paperwork, answered questions, and cooperated with the officer's request. After waiting nearly an hour, an investigator arrived and explained that another investigator would be assigned to the case so that she would not be speaking to the child that day. She interviewed the Spencers. They provided her with all the information she requested, including names, contact information, and every detail they knew to that point. They agreed to wait for a detective to contact them the following day to set up an interview with the minor. Spencer thanked the officers for coming, then cordially departed. The state's attempt to reframe this interaction as one in which Spencer was mainly concerned with the identity of the mandated reporter and his belief in the adequacy of the judicial system is not just false but completely tone deaf as to the situation the Spencers family suddenly faced and their fierce concern for their child. The state dismissed that Spencer did not refuse the officer's entry or refuse to cooperate or allow his child to cooperate. It certainly doesn't acknowledge the more than hour of he and his wife providing officers with any information they could help to put Fossler in jail. While Spencer was worried for his child and angry at his daughter's rapist and the people he felt protected the rapist and who they believe lied to officers, he was quickly calmed and cooperated. Footnote 2. Spencer and his wife were both concerned that the person who contacted police had lied to them. As they knew she was not a mandatory reporter, they were not told that she had spoken to a third party who is a mandatory reporter or any of the other context of that conversation. They believed that she had previously misled them about their child and had concealed the child's victimization at the hands of Fossler, her boyfriend. They were upset because it seemed with the information they had at the time that she was again deflecting from Fossler's actions by accusing someone in the Spencers family of wrongdoing. It is difficult to imagine many fathers not feeling and behaving the same way when presented with such horrific and shocking circumstances. What Spencer said then and believes still is that a parent has the absolute right to defend their child against someone who is presenting an imminent danger of harm, like manipulating a minor victim to have sex with him while awaiting a trial for numerous sex crimes against her, when the judicial system cannot or will not protect them. And what matters is what actually happened, not what the state tries to piece together from choosing words spoken months before the event that put the child directly within the control of her rapist. What really happened is that Spencer stood down. He did not attack Fossler when he confirmed his contact information. He went back home to talk to his family. Before they could do so, while preparing their child for the process of reporting this that she was about to go through, officers showed up unexpectedly. The next day, they delivered their child for a forensic interview and allowed the criminal process to play out. They did interviews, delivered and consented to searches of their electronics, provided witness information, etc. Fossler was arrested 4 days after the initial meeting at Spencer's residence. He was seen by a judge the following day, and it seems an order out of the circuit court was entered imposing a mere $50,000 bond and a generic no-contact order prohibiting Fossler's contact with any minor. It was not specific to the Spencer's child and did not include any restriction concerning their property or other places the child may be present. Despite the plentiful evidence confirming the use of social media platforms to commit the offenses, he was not restricted in his use of social media. He was not required to report to anyone associated with the court or law enforcement, and neither his internet usage or physical movements were monitored in any way. The state's response then begins to describe the early morning of October 8, 2024, as if Spencer planned this night of his daughter being sexually assaulted by the 67-year-old man in order to effectively take the law into his own hands. Such insinuations is offensive and absurd, and once again favors the pedophile instead of the victim. The state's own probable cause affidavit for the arrest of Aaron Spencer contradicts much it's described of the morning. Fossler died and certainly omits significant information about the events that led to Fossler's death. The affidavit states that Spencer told officers he had been woken up by his dog barking, which was uncommon, and went to check on his daughter. Due to the events that occurred earlier in the year, Spencer stated that the dog was in his daughter's bedroom. And when he opened the door, the dog continued to act out of character. Aaron Spencer further explained that when he looked closer at what he thought was his daughter in bed, he realized it was actually a stuffed animal with his daughter's hoodie on it. Aaron Spencer stated that he became scared of what had happened to his daughter and had his wife call 911 to report her missing. Aaron Spencer then stated that he left his residence and began to search for Michael Fossler and his daughter. Aaron stated that when he arrived at the intersection of Highway 236 East and Highway 31 North, he observed the white Ford F-150 belonging to Michael Fossler turning off of Highway 31 North onto Highway 236 East, heading towards his residence. Aaron Spencer then stated that he turned around, attempting to stop the vehicle by flashing his lights, blowing his vehicle's horn. Aaron Spencer stated that he was in fear for his daughter's life and continued to pursue Michael Fossler on Highway 236 East. Aaron Spencer explained that when they arrived at the intersection of Highway 236 East and Highway 13 North, he hit Michael Fossler's vehicle in the rear, causing it to slide off the road. Aaron Spencer then stated that he exited his vehicle with his firearm and ordered Michael Fossler out of his vehicle to lay down in the ditch. Aaron Spencer stated that he observed his daughter trying to exit the passenger side of the vehicle, but it appeared that Michael Fossler had grabbed her and stopped her from getting out. Aaron Spencer then stated that Michael Fossler exited his vehicle and had something in his hand, but did not know what it was. Aaron Spencer stated that Michael Fossler then lunged towards him, saying, "Fuck you." Aaron Spencer stated that he then opened fire on Michael Fossler, emptying his weapon before jumping on top of him and pistol whipping him. Aaron Spencer then stated that he got his daughter out of the vehicle and returned to his truck, where he reloaded his weapon and called 911. Spencer certainly never told officers he thought Fossler had entered their home and forced the child into his truck, but when Heather and Aaron Spencer found their daughter's bed empty, they were worried given what she had recently been through. They decided Heather would call 911 and he would begin searching for her in the area. They learned about that time from a family member that Fossler had recently contacted the child, and then they were understandably panicked. They were terrified that Fossler would not only sexually assault their child, but that he would kill her or disappear with her. Knowing that she was a critical witness to the crimes that would put him in prison for the rest of his life. Like any normal father, Spencer left his wife to stay on the 911 call while he went out to search for her. Contrary to the state's suggestion, there is absolutely nothing about him doing this that is unlawful or wrong. In fact, it is exactly what almost anyone would do. Yeah, I agree. Contrary to the state's misrepresentation in his interview after shooting, Spencer did not say he was vigilant for Fossler that night. Instead, he explained that he had learned what Fossler looked like, where he lived, what vehicle he drove, and because he was aware that no one was monitoring Fossler, and while he did not watch Fossler, he needed to know if Fossler was nearby. He was worried that without any real barriers in place, Fossler would seek the child out and hurt her again. He explained that he had thought he had seen Fossler driving near the Spencer's home several times, but he was not certain it was Fossler, and if it was, Spencer would not confront him and instead would let the police do their job. He remained aware of Fossler and aware that no one was watching him, so as he explained to investigators, Spencer stayed vigilant for Fossler if he came near their home. Spencer said nothing to investigators about immediately getting in his truck that night to look for Fossler because he was vigilant for him. He was, however, vigilant in his desire to find his daughter. While Spencer was looking for his daughter, he happened to pass Fossler's truck as it turned onto Highway 31. Several miles from where the Spencer's residence is located on the roadway, and Spencer saw his child in Fossler's truck. Spencer turned around to follow, and for miles, Spencer honked and flashed his lights, but Fossler sped up, fleeing with the child towards an intersection that would take them out of the area. Before that could happen, Spencer, having been trained in military tactics and maneuvers for disabling vehicles while avoiding significant injuries, pushed Fossler's truck into the driveway. Fossler exited the truck, coming towards Spencer aggressively with something in his hand, and Spencer shot him, unloading the clip. Fossler jumped into the ditch and continued to move and curse, and concerned that he may have had a weapon, Spencer hit Fossler with the gun to abate any further threat. The state suggests that Spencer had other options that night, including that he could have called 911 when he found Fossler with his daughter. That kind of hindsight is inappropriate and irrelevant. First and most importantly, there is no law whatsoever in the state of Arkansas that requires any citizen to call 911 in the face of immediate danger. Arkansas law provides every citizen the right to protect themselves and their family from threat of harm, and there is no condition to call 911 first and to see if that works out. Heather Spencer had already called 911, and Spencer knew that. Unless the sheriff's office were ignoring the call, they were on their way. If it takes a second 911 call to make officers move faster when a child/victim witness in a pending Y felony case is missing, that is a significant problem for the community. Third, the state's representations about Spencer's phone are simply wrong. Spencer explained to investigators that he could not get his phone to unlock while driving, and also that when he was going so fast he didn't want to have a wreck making a call. Not that he was driving so fast that he could not unlock his phone. The phone records confirm that this is true. He makes no call between the time that he located Fossler and the shooting. He spoke with a family member before finding Fossler with his daughter, and while a family member sent him text messages during the interim time, the forensic examination does not establish that he saw those messages at the time she sent them. A critical review of the phone data proves that the times correspond to when a text is sent and received and do not reflect an action to use the phone to read the messages. Once he saved his daughter, his first and only call was to let his wife know she was safe. Although he did not reach her, his next call was to 911. The state's assertion Spencer had good reason to believe his daughter had snuck out of the house and not had actually been kidnapped that night is outrageous. It is as if the state is portraying this relationship between a child sex assault victim and her abuser as a typical and consensual. The idea that a parent in this situation would reasonably believe that their child was safe in the circumstance is preposterous. Whether or not she was forcibly removed from her home, Spencer and any parent in that circumstance had good reason to believe the child was in danger. This is especially true here, where the rapist with control over the child is facing life in prison and the child is the sole witness. Even though it matters not how you label it, most reasonable parents would believe that this was a kidnapping too. The comments also demonstrate a reprehensible blame the victim mentality. The state seems to not understand the victimization of children by pedophiles like Fossler. The child was 13 years old when Fossler began to groom and assault her, turning 14 years old shortly before he was arrested in July of 2024. Among many other things, he told her often how much he loved her and manipulated her into believing him and believing that she loved him, even when he hurt her. Unfazed by the dozens of sex crimes he faced for his assaults against her and a no-contact order prohibiting him from contacting a minor, Fossler continued the pattern of grooming the child so that he could maintain his ability to control her and to sexually violate her until the very end. Neither the Spencers nor any reasonable parent would ever consider the circumstances as just a teenager who snuck out of the house. The state seems to be arguing that it was unreasonable for Spencer to believe that Fossler presenting a risk of harm to Spencer's 14-year-old daughter if he persuaded her to sneak out instead of forcing her out of the home. The state also seems to be arguing that Fossler did not commit any crime in persuading his 14-year-old victim to leave the house so that he could pick her up and at minimum have sex with her. But Fossler committed multiple felonies against the child that night. Yet the state seems to insinuate that Fossler did not in fact present a danger to his child victim on the night of October 8, 2024. An insinuation that is so flabbergasting it is difficult to comprehend. The state does not, however, offer the last piece of its theory that since the state says Spencer really believed the child willingly joined her rapist that night, he should have called police a second time rather than follow Fossler and secure the child's safety. The state does not explain how Arkansas law requires any person to refrain from acting in favor of hoping for a police rescue in the face of such danger. The state likewise does not explain how its proposed plan of action would have assured the child's safety. The state does not explain how Arkansas law required Spencer to choose to let Fossler flee with his daughter instead of intervening to protect her. Nothing that Spencer said months prior has any bearing on these issues. The only facts that matter are those that put a child victim under the sole control of the pedophile who had repeatedly harmed her. Spencer's anger months prior has in no way changes the scenario Fossler created that night. Whether Fossler forcibly kidnapped Spencer's 14-year-old daughter or groomed her so that he could continue to abuse her, if not disappear with her, the analysis is the same. Either scenario created a legal duty and legal justification and certainly reasonable cause for Spencer to act to protect his child from a sexual predator who refused to leave her alone and who presented a real threat to her safety, both as a victim and a witness to his crimes. The suggestion that if Spencer thought his 14-year-old child may have gone willingly with her rapist, Arkansas law requires him to sit back and hope for the best is outrageous. But this is apparently the core issue of this case. Thus, it matters not what Spencer felt or said months prior when he learned of Fossler's grooming and abuse of his child, because on the morning of October 8, 2024, Fossler, by his own choice, posed an immediate threat of harm to his victim, and Spencer had every right and indeed obligation to fight to save her.